Hello everyone and welcome to this video tutorial on discharge of contract. Discharge of contract refers to the different ways that a contract can be brought to an end. The most obvious way a contract is discharged is when all the parties have performed their obligations, but there are other ways for a contract to be discharged as well. Where a contract is discharged, each party is freed from their continuing obligations under the contract. This diagram shows the four methods of discharging a contract: by performance, by agreement, by breach, and by frustration. We're going to look at each one of these in turn, starting with performance. The general rule on discharge by performance comes from the ancient case of Cutter and Powell from the 1700s. In this case, a sailor agreed to serve on a ship from Jamaica to Liverpool, and he was to receive 30 guineas on completion of the voyage. Unfortunately, our sailor died mid-voyage, and his widow was trying to claim some of his wages for the part of the journey that he had completed. The court said that the widow couldn't recover anything because the contract was construed to be entire, and because he'd only done half of it, he was entitled to nothing. So the rule from this case was that if a contract requires entire performance and a party fails to perform the contract in its entirety, they're entitled to nothing from the other party under the contract. Hopefully you can see here that this is a bit of a harsh rule, seems unfair, because okay, he didn't do the whole trip, but he had done half of it, and surely he should have been entitled to half of the wages. So over the years, since Cutter and Powell, we have moved away slightly from this rule, which is a little bit harsh, and now we're prepared to accept performance, which is substantially performed. A case that illustrates this exception to Cutter and Powell is Honig and Isaacs. Here the claimant was decorating and furnishing the defendant's flat for £750. He completed the work, but our defendant wasn't happy, and there were defects in the furniture that amounted to £56. Now, if we applied Cutter and Powell strictly here, because he hadn't performed the contract entirely because there were defects, he would have been entitled to nothing under Cutter and Powell. But he's still done a substantial amount of the work. So the court said here that because our claimant has substantially performed the contract, he was entitled to the price, £750, minus the defects, £56. And I think that seems like a really logical rule. We always compare the case of Honig and Isaacs to Bolton and Medeva, and here our claimant was installing central heating and the contract price was £560. Again, like Honig, there were some defects, and these amounted to £174. Now here, the action by the claimant to enforce the payment failed because the court said that there wasn't substantial performance. In other words, the defects were too large compared to the agreed price, so unlike in Honig and Isaacs, where he could get this price minus the defects, here they sort of applied Cutter and Powell and said, no, you're not getting anything. So you always need to compare Honig and Bolton and understand that the judges are going to make a subjective decision on whether they think there has been substantial performance or not. Another exception to the Cutter and Powell performance rule is if you've got a severable contract, and that's illustrated in the case of Ritchie and Atkinson. By contract, our claimant here agreed to carry a cargo of specified hemp and iron. The price agreed was £5 a tonne for hemp and 5 shillings per tonne of iron. And the claimant only carried part of the agreed quantity. And the defendant was trying to argue Cutter and Powell, if you like, that he shouldn't have to pay anything because he hadn't supplied all of the amount agreed. However, the court said that the contract is severable. So because the price agreed was per tonne, the claimant was entitled to payment for the amounts supplied. And again, I think that's a logical rule. It's really easy for the courts to say, okay, well, he supplied 1 tonne, so he gets a £5. So look out for severable contracts. We can accept partial performance on those. It might be the case that one of the parties agrees or accepts part performance of what was initially agreed to. But from the case of Sumpter and Hedges, it's important that the party freely chooses to accept part performance and that they're not forced to accept it because they've got no other choice. It's also important that there hasn't been prevention of performance, and this is illustrated in Planch and Coburn. So in this case, our claimant agreed to write a book on costume and armour for the defendant, and the claimant had completed a large amount of work when the defendant suddenly cancelled. The defendant refused to pay the claimant anything, but the claimant was still willing to complete the original contract, and the claimant brought an action to enforce his payment. The court said he was entitled to recover money for the work completed because the only reason he hadn't done entire performance, if you like, is because the defendant had prevented that performance. And again, that's a very logical rule. It wouldn't be fair for our defendant to stop a claimant from doing what was contractually agreed and then say, oh, well, I'm not paying you because you've not finished, because they were the ones that prevented that performance. Let's have a look at the next situation then, discharge by agreement. With discharge by agreement, the parties themselves can agree to end the contract, form a new contract, or vary the original one. There are two situations we need to consider here, bilateral discharge and unilateral discharge. And the clue is in the name here, bilateral two-way, unilateral one-way. So the ideal situation is where both parties agree to discharge the contract. And the assumption here is that both parties are to gain a fresh but different benefit from a new agreement. So they both benefit, that's ideal. The less ideal situation is where only one party really wants to end the contract, and the benefit is only to be gained by one party who is then really trying to convince the other party to let them off the obligations of the original agreement. Now, because this is only one-sided, unless a unilateral agreement is under seal, consideration must be given in order to make the agreement enforceable. So a bilateral agreement is enforceable, but for a unilateral agreement, we need it made under seal. The way to discharge a contract is by breach. Where one of the parties fails to perform their side of the contract, the innocent party may be able to terminate the contract and commence proceedings for damages to compensate. There are two types of breach that we need to be familiar with, actual breach, where there has been a breach of the contract, and anticipatory breach. Anticipatory breach is quite interesting because this is where a breach hasn't happened yet, but one party indicates that they are unwilling or unable to perform their side of the contract. Let's have a look at a case on anticipatory breach then. We've got Frost and Knight, which has very interesting facts. Our defendant promised to marry the claimant on the death of his father. He then, while his father was still alive, said, actually, I've changed my mind, I'm never going to marry you. Now, our claimant was able to sue at once. And the principle here is that our claimant can sue for anticipatory breach of contract as soon as the other party indicates that they will not perform. Our claimant doesn't have to wait for the breach to occur. So here what we're saying is technically there wouldn't be a breach of contract until his father had actually died. But because he's indicated while his father's still alive, actually even when he does die, I'm not going to marry you, she can sue at that point in anticipation of the breach. In the case of Avery and Bowden, the court said that claimants should sue for anticipatory breach as soon as the other party indicates that they won't fulfill their side of the bargain. And the reason for this is to prevent the contract from being frustrated. And we're going to look at discharge by frustration next. But in this particular case of Avery, the Crimean War broke out, which frustrated the contract. Now, when a contract is frustrated, it unravels the contract. So that meant the claimant lost their right to sue for breach because they hadn't sued for an anticipatory breach. They were waiting for the breach to actually occur. So with anticipatory breach, the advice is sue as soon as they indicate they're not going to perform. The final way we can discharge a contract is by frustration. A contract automatically comes to an end if it's discharged by frustration. A contract may be frustrated where there exists a change in circumstances after the contract was made, which is not the fault of either of the parties, which renders the contract either impossible to perform or deprives the contract of its commercial purposes. And there are three key ways we can frustrate a contract: impossibility, illegality, or commercial sterility. Contract is found to be frustrated by one of these methods. Each party is discharged from future obligations under the contract, and neither party may sue for breach. So it basically just unravels the contract. The allocation of any loss is decided by the Law Reform Frustrated Contracts Act of 1943. The first way of frustrating a contract is through impossibility. And a classic example here is Taylor and Caldwell, where our claimant agreed to hire a music hall from the defendant for the purpose of holding concerts. Before the first of these dates, and without the fault of either of the parties, the hall was unfortunately destroyed by fire. And this case shows that a contract may become impossible to perform if the subject matter is destroyed. The contract is therefore frustrated through impossibility, the contract is unravelled, and neither side has to perform their obligations. So to give another practical example of this, although not a very cheery example, if I'm selling kittens and someone's given me a deposit for a kitten, and unfortunately the kitten dies of kitten flu before I hand it over, that contract would have been frustrated because it is now impossible for me to fulfill the contract because of destruction of the subject matter. And what would happen there, using the Frustrated Contracts Act, is that I would have to pay the deposit back, but obviously I'm no longer under an obligation to provide the person with a kitten. Possible to frustrate a contract through illness, and that's illustrated in Robinson and Davison, but be a little bit careful with this principle because this contract was frustrated where a specific pianist couldn't perform on a particular day. If, however, it's a job not requiring a particularly specialist skill, it might well be that the contract is not going to be frustrated just because of illness. Similarly, in the case of Nicole, a contract named an exact ship which was damaged at the time that the contract was due to be performed, and because they'd named that precise ship and another ship couldn't be used in its place, that contract was frustrated. It may also occur that we have temporary impossibility, where a contract's frustrated, where the eventual performance will be radically different from what was originally envisaged, and that's illustrated in the facts of Pioneer Shipping. It can be frustrated by illegality, so in Fibrosa, a contract was frustrated where the breakout of a war meant that we were no longer able to trade with Poland. To give a current example, the coronavirus, where we had lockdown, will have meant that lots of contracts would have been illegal to perform at that time because we were not allowed to go to work at that point. A contract can be frustrated through commercial sterility, where an event might mean that a contract is now deprived of its commercial purpose. And that's illustrated in Krell and Henry, where cancellation of a procession removed the commercial purpose of the contract. Always compare Krell and Henry to Herne Bay Steamboat, because in this case there was no frustration where there was still some use that could be got out of the contract, where there were dual purposes for the contract. The Law Reform Frustrated Contracts Act sets out what the consequences are when a contract's been frustrated. It will be discharged. Section 1.2 says that you can get back any deposit you might have paid before the frustrating event. And Section 1.3 says that if one party derived a benefit other than money prior to the frustrating event, then the other party may be ordered to give a just sum in respect of that benefit.